All right, we're going to call the full judiciary non-civil meeting to order. Right now we are one short of the number we need to vote on bills, but we're going to start hearing bills. First, before we get started, I want to acknowledge we've got some judges here with us today. From the Superior Courts, we've got Judge Billy Ray. Thank you, Judge Ray. We've got two state court judges with us this morning, Judge Larry Mims. Judge Mims, welcome, and Senior Judge Kent Lawrence. Judge Lawrence, thank you for being here with us today. All right, we're going to go. I know we've got several of the presenters have meetings elsewhere, so we're going to give Representative Hightower the opportunity to go first because he actually has a meeting in Carrollton. I don't think yours is that far away, is it, Representative Carter? Okay, good. All right. Representative Hightower, the floor is yours. And you can present it from right there. It's fine. You don't have to come around. Okay. What's your mic number? Does that get it?
I believe that's it. Give me 1 second. The bill that I bring before y'all today is House Bill 733. This bill deals with the Georgia Commission of Family Violence. It provides for a holdover provision for when people or when members of this commission are rotating off. Just to give you a little background, this commission was developed in 1992 by the state legislature, which developed this commission to state a plan for ending family violence in Georgia. Currently, what this commission does is they study and evaluate needs and services relating to family violence in Georgia, evaluate and monitor the adequacy and effectiveness of existing family violence laws, initiate and coordinate the development of family violence legislation, monitor and implement the enforcement of laws, regulations, and protocol concerning family violence, and a number of other things all centered around family violence and deterring family violence in the state of Georgia. What this provision would do, if you look at the bill, there's a line that's added, and it says each member shall serve until the date his or her successor is appointed. Right now, this commission does not have a holdover provision. So, in effect, if someone's term was to end, that person would have to vacate that seat immediately. The reason this is an important issue for us is because this year, if this were to happen, there is 24 people on the commission that would rotate off this year. So if this were to happen this year and we don't have some type of holdover provision until a new person is appointed, this commission would essentially cease to exist or cease to work, and that's why it's needed. Just to give you a background, we're really just putting this commission in line with most of the other commissions in the state. I'll give you a list of different commissions and different boards throughout the state that do have holdover provisions. State Personnel Board has a holdover provision, says members shall serve until their successors are appointed. Veterans Board, which is appointed by the governor, says members shall serve until their successor is appointed. Board of National Resources, again appointed by the governor, members shall serve until their successors are appointed. State Board of Education, again appointed by the governor, confirmed by the Senate, members shall serve until their successors are appointed. Board of Regents does the same thing. Georgia Agriculture Exposition Authority, I believe is what it says. State Soil and Water Conservation Commission, Agricultural Commodity Commission, Georgia Tobacco Community. These are just a list, and the list goes on and on. This is a provision that's usually placed in most commissions. We believe this was just an oversight that this type language was not placed in there, so we're asking this for your consideration.
Thank you. Do we have any questions from members of the committee? Representative Byrd.
Thank you, Representative Hightower. Are these paid positions or are they volunteer?
Actually, the guys who can answer more of the financial questions right here, y'all. This is Chuck Spahas. So he could probably answer that question a little better than I could.
I could. Mr. Chairman, no, these are all appointed positions. They're representatives of the Sheriff's Association, the DA's Association, I'm the Solicitor General that's appointed to it. Most are appointed by the governor. There's 3 House members. There's 3 Senate members. But no, the members of the commission are not compensated.
And not even with per diems?
Now, I do believe the statute authorizes travel, any actual expenses. I don't know that anybody ever submits them, but it does probably authorize travel. I think there's a provision in there that does that.
Thank you.
Representative Coomer.
I'd like to make a motion.
We now have a quorum, so we're in that posture. So I would certainly entertain a motion.
Move to pass House Bill 733, LC 37-1300.
All those in favor of the motion signify by saying aye.
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 Opposed? Hearing none, recommend do pass. Now, this is your first bill, right?
It is.
I would anticipate more than one question on the floor.
I was anticipating it for today.
Making notes over here, you know.
Thank you. Representative Carter, come on up. Yeah, that'd be great. Thanks.
Thank you, Mr. Chairman. Good morning, everyone.
Good morning.
I bring before you today House Bill 895. It's LC 295064-EC. It's regarding the Sexual Offender Registration and Review Board, which I'll also refer to as SORB, which seems to be easier to say. Back in 2006, the board was created, and its purpose is to determine risk levels for sexual offenders. And what we've realized is we have a backlog of offenders out there right now that the board is trying to evaluate, and the best way for them to evaluate these offenders is to actually have more rights than what they have. Currently, the SORB is connected to the Department of Behavioral Health and Developmental Disabilities, but what this bill does is it takes the investigators from the board and it puts them in the GBI, which gives them access to the history of these sex offenders so that they can have more information than what they currently have. Of course, this is a way for us to protect our citizens more. I think as much history as the investigators can get will certainly benefit all of us as citizens of Georgia. You'll see, I mean, if you want to look through the bill, you'll see some of the changes that have been made. It's some additions and a couple of things that have been stricken, but this will take effect July 1 of this year, and there are approximately 12 part-time and full-time investigators. This does not increase that. It's simply just moving them from one agency to another for access reasons.
Thank you. What kind of caseload do they have, just out of curiosity?
Well, currently, they have about 5,000 sex offenders in the backlog waiting to be leveled and risk determined. So it's a pretty big deal.
Right. Representative Coomer.
Mr. Chairman, I would just add, I know of an attorney in Cartersville, Georgia, who has a private practice there and who happens to be in this General Assembly, who handled a case that would have been affected by this a year ago. And the wait was substantial in trying to get the case processed. And frankly, if the board had access to the GBI files, not only would the case have processed more quickly, but probably would have been processed in a different manner due to the fact that certain information may have been withheld from that attorney by his client until he got on the stand to testify. So it would have been helpful to have this kind of information going in. I think this would be a good bill. I'm going to support it.
Thank you, Representative Coomer.
Well, there's no question, so do I hear a motion from you?
Yes. I move do pass LC 295064-EC, House Bill 895.
All those in favor of Representative Coomer's motion, please signify by saying aye.
Aye.
Opposed? Hearing none, recommend do pass House Bill 895. Thank you, Representative Carter.
Thank you.
All right, we're going to stand down for a minute while we get the next bill author down here.
move for Mr. Atwood be publicly flogged for being late.
All right, we're going to call the hearing back to order, and we're going to turn the floor over to Representative Allison, who is presenting House Bill 372. It's LC 211123, correct?
That's it, sir.
All right. Thank you.
Thank you, Mr. Chairman, members of the committee. I present House Bill 372. Many of y'all have seen this bill before. This was a bill that came through the full committee unanimously last year and got hung up in rules and therefore was resubmitted back down to the committee. What this does, this is brought on behalf of the Clerks Association. What this has to deal with is unclaimed cash bonds. Basically, right now, if a criminal defendant in a criminal matter pays a cash bond to the clerk once his case is disposed of, he is sent a notice that he can come pick up his cash bond. Right now, under law, the clerks have to hold that money for 7 years. And as many of us know, a lot of people who are paying cash bonds relocate. They move out of the jurisdiction where the crime took place. So the best chance of getting them is in the first 3 or 6 months. This bill right now has them hold on to that money for 7 years. It has become a kind of an accounting nightmare for clerks to hold on to the surety for 7 years. What this bill would do basically is reduce that time from 7 years down to 1, and that's all this bill does, Mr. Chairman. I'll be happy to answer any questions.
Is that a kind of how in terms of the time periods other states hold these bonds? Have you taken a look at that at all?
I have not. This was just something
kind of
that
the
came
time
from
period
clerk.
they recommended it was workable from an
Yes,
administrative standpoint?
Okay. Yes, sir. And Mr. Chairman, the one thing I want to reiterate, like I said, most of the times, as soon as the case is disposed of, whether it be a plea or not guilty verdict or whatever, they're going to be notified by the clerk, according to this, within 90 days following that disposition to come pick up their money. The address we have at that time is always going to be the best address. If you're talking about someone who has relocated 2 or 3 times since, obviously forwarding mail would have disappeared, so holding on to it for 6 years does nothing more than become an accounting hassle.
And you said we heard this last year, right?
You heard
We
this
passed
last
it
year
out
and approved.
There was no
passed out
issues,
unanimously.
Right.
No
Okay.
issues. And has not changed since that time.
All right. You have one question, Representative Byrd.
Thank you, Representative Allison. Where does the money go?
Goes to the local. It'll go to your local county. So if this was a Cherokee County case, it would be turned over to the general fund of Cherokee County, the county in which where the bond was posted.
Is there any reason why we couldn't use those dollars for indigent defense?
I guess I guess that would be something to be considered. But right now, it's right now directed to the general fund of the county in which the crime was charged.
Representative Coomer.
Just to follow up on that, Representative Byrd's question, and Representative Allison, you can correct me if I'm wrong, or actually let me just ask you, isn't it true that the counties themselves actually pay part of the indigent defense costs?
That is correct.
Okay, thanks.
All right, can I get a motion from a member of the committee, Representative Coomer?
Sure, I'll move. Do pass. LC 295116. Am I in the right bill?
No, you're
No,
not at all. But
I think we already did pass that one. Yes, move do pass House Bill 372, LC 211123.
All right, all those in favor of Representative Coomer's motion, please signify by saying aye. Aye. Opposed? Hearing none. Committee recommends do pass House Bill 372. Thank you. All right, we're going to stand down again until we get our next and final author, Senator Calsert. All right, we're going to call the hearing back to order. Chairman Calsert, come on up. You are going to be presenting SB 236, and I think just if you can confirm we've got the right LC number, 295116 ERS. Is that right? Okay. All right, the floor is yours.
Thank you. This bill came through Chairman Setzler's subcommittee here last week or two, and it's a bill that's been bandied about for about a year. It's brought by the Council of State Court Judges. The idea behind the bill is to encourage people to participate in drug and alcohol rehabilitation programs, both state-mandated programs as well as DUI courts. These are referred to often as accountability courts. They're extraordinarily effective in reducing recidivism on DUI drivers. The idea is that you need to rehabilitate these people and cure the problem rather than let them just continuously drinking and driving and getting caught. The recidivism rate is just amazingly low. It's about 13% for people that go through these programs and complete the programs. They're very intense probation, monitored by the judge of the DUI court. The offenders have to appear usually on a weekly basis. They're subject to an enormous amount of drug and alcohol testing on sometimes even more than a weekly basis. And once they buy into sobriety, they don't repeat their offenses, and it's just statistically proven. Judge Kent Lawrence from Athens was one of the pioneers in this field. We had, I think, the second DUI court in the state of Georgia, and he is a national authority now and goes around speaking around the country about the effectiveness of these and how to do them. He found that one of his problems was that people with multiple DUIs, and that's who these courts are intended for. They're not for these DUI court programs, or if you've gotten more than one DUI. That one of their impediments is they're not able to get there. This requires such intensive probation and counseling and treatment and testing that you have to have a means of transportation to participate in the program to get the benefits of the rehabilitation. Our law on a second DUI offender does not permit you to get a limited driving permit. If it's a first offense, you're allowed to get a limited driving permit to get you to work, to get you to school, to get you the necessary medical treatment. On a second DUI offense, those are not permitted at all. In fact, it's a hard suspension for a year. You're not able to drive for any reason for a year. So what Judge Lawrence and these other judges in the DUI court programs found is the people that most need to participate in them are sometimes physically unable to get there due to transportation needs. What this bill does is change our law so that you are able to get a limited driving permit on a second DUI offense under very, very limited circumstances. You must either be enrolled and involved, actively participating in a state-administered alcohol rehabilitation program, which is provided under the DUI statute, or else be enrolled and participating in a DUI court program. You must wait 120 days under any circumstances. So 4 months you would have what's referred to as a hard suspension. You would not be able to drive at all, even to go to this treatment and rehabilitation. The reason for that is these judges have learned that the person has to buy into their sobriety and have to be committed to mending their ways, to healing their problem, and it usually takes about 60 days to do that. National standards require that you be at least 45 days without a license. This is more than double that at 120, and all the judges are very comfortable that at this level the person is unlikely to repeat their offense because they are well on their way to sobriety and rehabilitation. The judge has to approve the limited driving permit. It's not an automatic right, so you have to be enrolled in one of these programs, and your sentencing judge has to say you're a suitable candidate after 120 days. It has to be limited to very precise reasons, and mostly to get to your treatment. And you have to put an interlock ignition device on your vehicle so that it will not crank unless you've breathed into it and proven that you're not impaired at all at the time you use that limited driving permit. If at any time, of course, you're subject to constant testing. If at any time you violate your sobriety, violate any of the terms or conditions of your probation, then this limited driving permit will be revoked. So it's left to the discretion of the court. It's very limited under those circumstances, and we think it's a great idea to help cure the problem. This has been vetted extensively. The National Highway Traffic Safety Administration has reviewed it and approved it. There is a federal law that's called Safety Lou. I don't really know how that's spelled, but it sets forth all the requirements on DUIs nationwide so that we can stay eligible for federal funding. And this limited driving permit program complies in all respects with that. It's been vetted and approved by NHTSA. And this is also supported by Mothers Against Drunk Drivers. That's say it is a step in the right direction for doing this, and the Council of State Court Judges. Mr. Chairman, I think that gives you the summary of what we're doing here. I'm happy to answer any more specific questions that you may have.
And this is, I'm sure this is true, but just to clarify, just as the judge has to approve the limited driving permit, if the offender doesn't show up or is not meeting the end of the bargain, I'm sure they can terminate it as well, correct?
Absolutely.
Yeah. Yeah.
Thank you.
Representative Byrd.
Thank you, Senator. I'm looking on page 2, lines 55 and 56, and it talks about electronically online. Is there safeguards if someone is actually taking those courses online? What does that mean, please?
That's a good point. This particular section was added as a floor amendment in the Senate. It has nothing to do with the underlying bill on limited driving permits. This is a alcohol education program for young people in high school. It's intended to be taken before you even get your driver's license. We had a senator from Gainesville that was very concerned about this, that parents were not required to be involved in that program, and it's been proven to be more effective if parents and children take it together and they buy into, kind of a family agreement as to whether or not you drink. That is completely separate from the underlying bill that deals with limited driving permits. This is a voluntary drug and alcohol course, and it makes it voluntary for parents or guardians to participate if schools provide that particular program. It was not part of my original bill. But I had no objection to it. I mean, it's a voluntary thing. It's just the schools that do offer these type of alcohol education courses for young people. This was to encourage them to allow the parents to voluntarily participate in it, and it expanded to where that could be done online if the commissioner of the Department of Driver Services authorized anybody to do that. That's not a program required to get a driver's license. Or
this is not a mandate.
It is not a mandate.
Thank you.
Representative Atwood.
Thank you, Mr. Chairman. Senator, thank you for bringing this bill. Looks like good legislation. Just, I want to be sure I understand, though. You're not saying that this is a new standalone court, that it would exist under the existing state court system that we have?
Correct.
Just a new program.
It is not a new program. It's a current existing program, and it's actually defined in law under, they're referred to as drug courts, but
Gotcha.
the official term is drug and alcohol treatment courts, and that's something that's already in existence under Georgia law. They're not provided in every county. I want to say there's, for some reason, the number 70 sticks in my mind around the state. Some counties do not have these. It's an optional thing, and where you don't, then there are state authorized rehabilitation programs that are provided.
Yeah, I concur with you. I've done some research in this, and the recidivism rate is, your statistics are on point.
It's really impressive, and practicing law in Athens, I see it a lot, and it's particularly with young people. It's just extraordinarily effective. Once they deal with their underlying problem, they have to want to do it, and it is an incentive ordinarily from the court in the sentencing end of things that they may get a lighter sentence if they agree to be in this very intense probation. And the program lasts 1.5 to 2 years, and it's interesting how, and where Judge Lawrence's point is, that some people might get into that program just hoping to get a lighter sentence. So it takes them a while to recognize that they had an alcohol problem and to buy into it. That's why the 120-day waiting period.
Representative Neal.
Hello, good morning.
Good morning.
My apology. You might have addressed this in my absence, but if you could clarify this. 2A, 96 to 103. If you could just tell me in layman's terms exactly what that does.
You're on page 3 there at the bottom.
Yes.
Okay.
Just that section, if you can explain exactly what that does.
That lists the penalties based on the number of, or the license suspensions based on the number of convictions you have. 2A deals with a first conviction for DUI, and of course it says that the period of suspension shall be for 12 months. Under B there, starting at 104, gives the suspension for a second conviction, which is a period of 18 months, so that's a year and a half. And at line 108, it gives the penalties for a third conviction, which is essentially a revocation of your license there.
Okay, I was just trying to see the difference between the original language. Another question I had was, when it comes to the courses, are they going to be giving these courses at the driver's license centers?
The courses?
The 2031, line 31. The Commissioner of Driver Services to make available officers, employees, officials.
That's back the portion that's not really related to the limited driving permits.
Okay.
That's a alcohol education course.
Mm-hmm.
That's ordinarily provided in the school system. Good morning, Judge.
Okay. Yeah. Okay. Thank you.
All right, we had two people that wanted to testify on the bill, and I think you were just joined by one of them, Judge Lawrence.
Yes, sir.
I really don't have much to say, Mr. Chairman. I'll be brief. There are 8 other groups that are supporting this legislation. They're on record: the American Judges Association, the Governor's Highway Safety Association, International Association of Chiefs of Police, Mothers Against Drunk Driving, National Alcohol Beverage Control Association, the National Association of Prosecutor Coordinators, the National District Attorneys Association, and the National Sheriff's Association. We have now currently as of December the 31st, nationally we have in operation 569 impaired driving court programs. 395 are hybrid courts. They contain both possession, felony offenders, drug offenders, and also DUI offenders. And we have now nationally 174 DUI standalone courts. At this time in Georgia, we only have 22 impaired driving court programs, but we think that we'll be increasing that number significantly in the next 2 or 3 years.
Thank you for coming down and testifying. We really appreciate it. Stephanie Woodard was next on the list.
Good morning.
Hey, Stephanie, come on in.
I'm Solicitor General in Hall County. I do want to let you guys know that the Solicitor General's Association has voted unanimously to support this. We have had a DUI court in Hall County now for almost 7 years. We were right behind Judge Lawrence.
Who's the judge up there?
Charlie Wynn. And Jason Deal also has a hybrid court in Dawsonville, both drug and DUI court. We are so hopeful and thankful that Senator Calcert has carried this legislation. It is exceptionally necessary for our participants. I did want to tell you that during Phase 1 and Phase 2, our participants are tested up to 10 times a week. In our program, they are screened independently by our treatment services. They are screened every time they appear for treatment. They are screened every time they appear for court. What is so phenomenal about this is that we jokingly call it the judge giveth and the judge taketh away. With any positive, not just on the interlock that will be in the car, any positive screen, it can be revoked. With any non-compliance, if they fail to show up for treatment, if they fail to comply with even their AAs or their community service, it's not tied to just being positive. The judge can suspend this privilege for any program violation. And we're just incredibly hopeful. I affectionately call DUI court Krabby Court, because unlike drug court where substances are illegal and everybody knows they're not entitled to use drugs, alcohol is a legal substance. So that 120-day period is necessary to penetrate what is clearly some substantial misuse. You have to be a second and 5 offender to be in DUI court. But it's almost more dangerous because they are substances they can legally access or legally capable of using but for this risk-taking and extremely dangerous behavior. This helps people be able to still work to get to their treatment. We are much more of a rural geography, so I have people that live on north ends and south ends of the county that have to travel substantial distances to be able to attend treatment. And this is just vital. So I'm here to say please, 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 and thank you.
Thank you. Nobody else has signed up to speak on the bill, and there are no other questions, so we're in the posture of being prepared to take a motion. We have a motion from Representative Cooper.
Pass the substitute to Senate Bill 236.
Second. All right, all those in favor of the representative's motion, please signify by saying aye.
Aye.
Opposed? Hearing none, the committee recommends do pass SB 236. Who's going to carry it on the floor for you in the House?
I was hoping you would, but I hadn't had a chance to talk to Representative Atwood would volunteer too.
I'm happy to do it, or if Representative Atwood has a passion for it. So, well, I'll tell you what, he and I will talk about it after the meeting, and we'll give her a name, and we'll get it taken care of for you. Yeah.
I'm happy either way, but we're proud to work with either of them.
We'll figure it out. Thank you.